You say your views are irrelevant, but they're not irrelevant if your task is going to be revisiting the manual to determine whether the manual should be changed. That section also provides, both as a matter of fundamental fairness and in the interest of efficient administration of justice, no prosecution should be initiated against any person unless the attorney for the government believes that admissible evidence is sufficient to obtain and sustain a guilty verdict by an unbiased trier of fact. I ask about this section in light of a few things, in light of the fact that, for example, in the case of Letitia James, the U.S. Attorney has now repeatedly gone before a grand jury.
This may look like a routine nomination hearing, but it's actually a stress test of integrity inside one of the most powerful systems in the country. What's really being tested here is whether justice in America is guided by standards or by ambition, politics, and pressure. When prosecutors pursue cases they don't believe can stand up in court, it's not just a procedural mistake. It chips away at public trust and the legitimacy of the system itself. This raises broader questions about fairness, accountability, and whether rules inside the Department of Justice are genuinely enforced or merely aspirational. In this video, we'll break down how this exchange exposes the tension between power and responsibility and what it means for democratic credibility, prosecutorial ethics, and the future of justice in the United States.
Follow up on that, since you raised interesting questions, but let me just ask you, you're an ordained elder in your church, is that correct?
In my former church, I've actually transitioned to a different denomination, but in a bit of a transition period, I still maintain my ordination. We'll resolve that through the Presbyterian order at some point in the near future.
Well, let me just ask you this. If you are confirmed to this position, what is the law, rule, and authority that you will be bound to follow as a member of the judiciary?
That is the United States Constitution, applicable federal and state statutes, and binding precedent.
Can you, in good conscience, consistent with your religious beliefs, including the ones that Senator Kennedy was just asking you about, can you, in good conscience, submit to the United States Constitution, all relevant laws, precedents, and so forth, and apply those faithfully if confirmed?
Absolutely, Senator.
Can you do that without reservation?
Without reservation. That is the oath that I will take.
Would that be your highest legal authority as a member of the judiciary, should you be confirmed?
My highest legal authority is to my nation, and that our nation is governed by the United States Constitution.
And the supreme law of this nation, which is positive law, which is the United States Constitution, statutes and precedents and the relevant order.
That's correct.
What we see here is the nominee declaring allegiance to constitutional authority above ideology or personal worldview. That matters because judicial credibility rests on whether citizens believe judges can set aside bias. If this commitment holds true, it protects the judiciary from becoming an extension of politics. If it doesn't, the courts risk losing legitimacy, and with it, public trust in equal justice under law.
Correct.
Senator Schiff.
Thank you, Mr. Chairman. Mr. Burrows, thank you for taking the time to meet with my staff. I understand one of your responsibilities in the Office of Legal Policy would be to revise and oversee the Justice Department manual. Let me ask you about the manual, in particular, one section of the manual, 9-27.220, which provides the threshold requirements for prosecution. It states that a prosecutor may commence or recommend federal prosecution only if he or she believes that the person will more likely than not be found guilty beyond a reasonable doubt by an unbiased trier of fact, and that the conviction will be upheld on appeal. Do you agree with that policy in the Justice Manual?
Thank you for that question, Senator. I believe that policy is consistent with the prosecutorial ethics codes of most states, and certainly if I go to the Department of Justice, all the prosecutors there are bound by the Justice Manual and other policies of the department. My personal beliefs about whether it's correct are sort of irrelevant at that point, but nonetheless, I have followed that requirement throughout my career.
This isn't just policy. It's a safeguard meant to prevent prosecutors from weaponizing power recklessly. When the justice system acts only where evidence is strong, it reinforces fairness. Undermine that principle, and prosecutions become political tools, not instruments of justice. That's the difference between a justice system people respect and one they fear.
As a prosecutor, 6.5 years in the U.S. Attorney's Office in Denver, as well as...
Mr. Burrows, I just want to make sure, you say your views are irrelevant, but they're not irrelevant if your task is going to be revisiting the manual to determine whether the manual should be changed. That section also provides, both as a matter of fundamental fairness and in the interest of efficient administration of justice, no prosecution should be initiated against any person unless the attorney for the government believes that admissible evidence is sufficient to obtain and sustain a guilty verdict by an unbiased trier of fact. I ask about this section in light of a few things, in light of the fact that, for example, in the case of Letitia James, the U.S. attorney has now repeatedly gone before a grand jury, and grand juries have returned no true bill because they found that the standard for probable cause could not even be met, a much lower burden than beyond a reasonable doubt. Career prosecutors had recommended against those cases for exactly this reason, that they did not believe it met the Justice Department manual standard. That is, they did not believe it could be proven beyond a reasonable doubt. In Los Angeles, we have another U.S. attorney like Halligan, unlawfully appointed, named Bill Asaley, who has apparently gone before the grand jury so many times and received a no bill from the grand jury that his nickname in the office is now No Bill Asaley. As a result of, in fact, he was overheard apparently, reportedly, by a grand jury screaming through the phone, F the Justice Manual. Now, what portion of the Justice Manual he wanted to F wasn't clear, but it is clear that grand juries continue to refuse indictments and that a lot of the career attorneys are leaving that office in droves. The office is down more than 80 attorneys, dozens have left.
This moment points to an institutional stress fracture. When prosecutors push cases beyond ethical standards, it signals a breakdown in internal checks and accountability. It raises a serious question. Is justice being pursued responsibly, or are offices prioritizing outcomes over integrity? That kind of dysfunction doesn't stay internal. It erodes the credibility of the entire justice system.
Many citing moral dilemmas being posed by the leadership of that office. So let me ask you this, what would the remedy be for prosecutors that are willfully ignoring important provisions of the Justice Manual?
Senator, I think your question brings up two things. First, I think it's important to note that the Office of Legal Policy is not involved in decisions in any particular investigation, any particular prosecution. Our job is to set forth broad parameters under which prosecutors would exercise their discretion that they have.
No, I get that, but you establish a policy or you affirm a policy such as you don't seek an indictment where you don't believe you can prove the case at trial. What do you do? What do you recommend? What sanctions should be applied to prosecutors that repeatedly, willfully ignore that basic principle of fairness?
So I have not been read. I don't understand the details of the actual internal process of the Department of Justice. I haven't had that come up in my career. Nonetheless, my understanding is that if people are violating departmental policies, there are various ways, whether it be through employment discipline channels or whether it be through the professional responsibility offices, that those are dealt with. But nonetheless,
here, the issue shifts from ethics to enforcement. Rules only matter if violating them has consequences. If prosecutors can repeatedly ignore fairness standards without real accountability, then policy isn't protection. It's theater. That distinction determines whether justice is principled or performative.
Have been.
If I could just ask, and I know my time is running out, one last question. Would it be appropriate then for attorneys who are willfully violating important policy provisions in the Justice Manual, like you don't seek an indictment where you don't believe you can prove the case, to be referred to the Office of Professional Responsibility for potential sanctions? Would that be appropriate?
May I answer the question, Senator? Senator, those are questions for the people that are in supervision over those people, which is not the Office of Legal Policy. That would be the Deputy Attorney General and the Attorney General.
But you will support that policy that I read to you?
I don't have any reason to think that that policy needs to be changed, no.
Thank you, Mr. Chairman.
Senator Blackburn.
Thank you, Mr. Chairman. And again,
this moment underscores a recurring challenge in American institutions: responsibility without clear ownership. Policies sound good, but if nobody is firmly accountable for enforcing them, then public trust relies on assumption, not assurance. And in a democracy, assumption isn't enough to sustain faith in justice. This hearing isn't just about one nominee. It's about whether the justice system still treats fairness as a non-negotiable standard. When leaders acknowledge principles but hesitate on enforcement, the system quietly shifts from certainty to doubt. And doubt is dangerous. It weakens trust, legitimacy, and the belief that power is being exercised responsibly. Accountability isn't optional. It is the foundation that keeps democracy credible, justice respected, and citizens confident in the rule of law. If institutions fail to enforce their own ethics, public trust collapses long before the system does. Subscribe to Liberty Report USA